And next we're going to have up Ms. Leslie Gaines, who came from not Gainesville, but Daytona. And she will be speaking with you about Social Security disability law. All right, again, she's going to speak just for 20 minutes. She does not have slides. She just wants to talk to you. Okay, so she's going to speak for about 20 minutes, and then we'll give her 40 minutes of Q&A. So we hope that you have lots of questions for her.
Well, thank you all for holding on to listen to my presentation. And I've actually been answering a few questions for people who've pulled me to the side, so I'll try to remember to restate those out loud just in case it might be helpful to someone in the audience. As Stuart said, I'm going to be discussing Social Security disability, and I'll start off by saying that the Social Security disability process and rules, it's very complex. So what I'm going to give you today is just kind of a broad outline of the way the system works and just some helpful, I guess you could say, helpful tips that if I were going through the process that I would want to know. So today I'm going to cover 5 areas. We're going to talk about how do you apply for the benefits. We're going to discuss the work requirement. We're going to discuss Social Security's definition of disability. We're going to discuss the actual claims process. And then finally, we're going to discuss ways that you can hopefully help your case if you're going through this process. Just a survey of the audience. Is there anyone out there who's actually currently going through the process now of trying to get Social Security disability benefits? Okay, I see one hand in the back. Is there anyone out there who's actually getting Social Security disability, not retirement, but disability? Okay, so quite a few. And then do we have any veterans in the audience by chance? Okay, so we have a couple. Today I'm talking about the Social Security, but just for the veterans in the room, sometimes there are benefits that you may be eligible for through the VA. And if you want to speak with me about that later, we can talk about that. So how do you apply for Social Security disability benefits? There are 3 ways. You can apply online, you can apply over the phone, or you can also apply in person. If you decide to apply for the benefits online, you can kind of go at your own pace with doing your application, but I would caution you to make sure that after you have applied, it should give you a receipt that basically will say, "Thank you, Ms. Jones, for applying. Here's your receipt number." Make sure that you print that or you write that down or you hold on to that because, unfortunately with technology things happen, and if it ever becomes an issue, when did you file, what's your filing date, or Social Security just mysteriously loses your application, then that way you have that to reference. That's if you're going to go with the online route. If you're going to apply over the phone, Social Security has an 800 number that you can call, and they're really, really backlogged. So when you call them, they may say, well, I may not be able to actually take your application for another month or another 2 months. So when you call, make sure that you let them know, I want you to know that I called on this date, made my appointment, so that way you protect your filing date. The other way, you can do it the old-fashioned way and apply in person at your local Social Security office. I'm not discouraging that way to apply, but it's generally easier to go one of the other routes. I would also say, just in general, when you're dealing with Social Security, if you send in paperwork to them, I always recommend that my clients send the paperwork certified mail, return receipt requested. So that way you can prove that you actually submitted paperwork, that it was actually received at Social Security. And make sure that you also keep a copy of any paperwork or any documentation that you're sending in. Please don't just send your only originals if you're going to mail. So basically, after you file for the benefits and you get to the point where they're taking your application, then you're going to speak with a claims representative, or if you're doing it online, there will be forms. And the forms are going to ask you a lot of questions about yourself. The forms will ask, well, what conditions are you claiming that are disabling? They will ask about your work history for the past 15 years. Where have you worked? What were your job duties? They'll ask about your medical treatment. Who are your doctors? What medications are you taking? So it's a pretty thorough process, and it's best to have all of your information together before you actually file for benefits, so that way you're not held up with Social Security needing information that you're not prepared to provide. After you get through the process of actually applying for the benefits, most people automatically jump to, well, I'm disabled, and so let's talk about the medical issues. But with Social Security disability, a lot of people don't know that there is actually a work requirement in order to qualify for the benefits. And basically, what I mean by that is you had to have worked long enough and recently enough, paid Social Security taxes recently enough in order to actually be insured or covered for the benefits. And Social Security refers to that as being fully insured. Are you qualified? Do you have enough quarters of coverage? And basically, it depends on your age as far as how long you had to have worked and how many quarters of coverage you need in order to be eligible. Obviously, if you're a younger person, then you haven't been alive long enough to work long enough to earn as many credits as someone who would be older. So the general rule, I'm just going to give you the general rule. If you are 31 years old or older, you have to have worked and paid Social Security taxes for 5 out of the last 10 years. And basically, for each year, you can earn up to 4 quarters. And for 2014, it takes $1,200 to earn 1 quarter of coverage for this year. So once you've made $4,800 in the year, then you've earned all 4 quarters for this year. If you don't meet the work requirement, then basically Social Security is going to say, sorry, you're not insured for these benefits. And the technical term is, what is your date last insured? Or you'll hear some people say your DLI. So that's what they're referring to. Now, if you're not insured for Social Security disability benefits, it doesn't mean that you're not eligible for any type of Social Security. There are other programs like SSI, which stands for Supplemental Security Income. And a lot of times people discuss SSD and SSI interchangeably, but they're not the same thing. They're different programs. And then there are other programs that you may qualify for. So once you've applied for the benefits, once you have passed the work requirement, then that's where you kind of get into the nitty-gritty, so to speak, of the Social Security process. And you have to look at, well, what is Social Security's definition of disability? And Social Security has their own definition of what they consider a disability to be. I spoke with a young lady earlier who told me that she was getting long-term disability benefits, but she's been denied with the Social Security process. And your short-term disability companies, long-term disability companies, VA, each company or agency has their own definition. With Social Security, basically, they're looking at, does your condition prevent you from working? And working is a particular term of art, but does your condition prevent you from working a minimum of 12 months, or is your condition terminal? So that's kind of the general Social Security definition. A few points I want to make about that definition. That doesn't mean that you have to wait 12 months before you apply for Social Security. What it means is that your condition has to be expected to last for 12 months. So if you're today, for example, and you feel that you're not going to be able to work, don't delay with filing for Social Security. Go ahead and file for Social Security. And let's say 9 months from now, if you make a recovery and you're able to return to work, well, then you can always withdraw your application. But don't delay filing because it does take quite a while. The part of the definition, is your condition terminal? I think that's pretty self-explanatory. With some of the other agencies, I mentioned VA earlier, you can have varying levels of disability. So with VA, you can be 10% disabled or 40% disabled. But with Social Security, it's an all or nothing. Either you're disabled or you're not, based on their definition. When Social Security takes your application, they're going to ask you, are you working? And I mentioned earlier that working is a term of art. Basically, they're looking to see, are you engaging in what they call SGA, substantially gainful activity. For 2014, the monetary amount for SGA is $1,070 on a gross basis if you're not blind. If you are considered to be blind, then you're allowed to make more than that. But the general rule is $1,070. So let's say that you are working part-time but you don't feel like you can work full-time and you want to file for Social Security disability. If you are making that $1,070 a month on a gross basis, well, then you're considered to be working even if your hours may be part-time. So you're going to be over the limit. If let's say that you're working and you're working part-time and you're making $500 a month on a gross basis, well, yes, you can file an application and you can still proceed with the process. And to be honest with you, when you get to the stage where you have a hearing with an administrative law judge, it may just depend on the judge that you end up with as far as what happens. And you would be able to testify, and I'll talk a little more about that, about why you can't work more. But just that monetary amount that you're earning, if you're under that limit, you can still proceed with your application. So once you get past that part of it, then basically Social Security is going to look to see, is your condition severe? And when they look to see, is your condition severe, then that step generally isn't very hard to prove, meaning if you have a condition or conditions that interfere with your ability to work, and if it's going to last 12 months, then pretty much you kind of breeze through that step. Once you get past that, then Social Security is going to look to see, well, what are the disabling conditions that you are alleging? And it doesn't have to be just one thing. We've heard a lot today about all of the effects of MS and the residuals that come with having that diagnosis. So Social Security will take all of that into consideration when deciding whether or not you're disabled. So you're at the step where they're looking at all of your conditions, and basically the first thing they're going to do is look to see, do you meet a listing? And a listing is technically known as the listing of impairments, but basically Social Security has an extensive list of almost every condition under the sun you can think of, and they have listings for neurological conditions, for mental conditions, for visual impairments. There's a criteria that they look at, and they're going to say, is the condition severe enough that you actually meet a listing? If you meet a listing, then basically Social Security assumes that your condition is so severe you're not able to work. I pulled the listing for MS just to give you an example of what they're looking at. They're looking at disorganization of motor function, Do you have significant and persistent disorganization in two extremities, resulting in sustained disturbance of your movements? They're looking at your ability to use your hands and your fingers, your gait, your balance, your locomotion, those sorts of things. They look at, with the listing, any visual or mental impairments. And then for that, they refer you to the listings for visual and mental. So they're looking to see, do you have secondary cognitive effects or mood changes or things that are severely interfering with your day-to-day activities? Also, they look at your fatigue after repetitive activities. So those are all of the things they look at to see whether or not you meet a listing. I can tell you from my experience, it's pretty hard to actually meet a listing, because that's when Social Security considers it to be just so bad. They know it's disabling. If you don't meet a listing, you can also try to equal a listing. So if you don't precisely meet it, but you're close enough to it, then they can take that into consideration. And obviously, you would need medical evidence to prove that you equaled a listing. But if you don't meet or equal the listing, it doesn't stop there. Then Social Security will move on to the next step, which is basically they look at what type of work have you done? What is your past relevant work over the last 15 years? So they're looking to see what kinds of skills do you have? How long did you do your past jobs? Are you able to do any type of work that you've done in that 15-year period? And it's important to know that Social Security is going to have vocational experts and people to testify about, for example, if you were a cashier, well, what does that job involve? What are the duties? And they're looking to see, do your disabling conditions prevent you from doing any of your past work? If they find that you're able to do your past work, well, then you lose, and the analysis stops there. If you make it past that fourth step, are you able to do your past work? Then you go to step 5, which is there any other type of work in the national economy that you're able to do? So for that step, they're looking at your education level, they're looking at what are your skills and your disabilities, and are you able to do a different type of job? The young lady I was speaking to earlier today shared with me that someone at Social Security told her, well, you're not going to win your case because you can be a greeter at Walmart. And and it's not really funny because I'm not surprised, but they do look at, well, what jobs are out there and whether or not you can actually do those jobs. Can you be a ticket taker at a movie theater? That's a job they like to use. Can you be a telemarketer or a surveillance system monitor? I don't think I know what that job is, but that's one that they discuss. So they will look to see, is there any other type of job that you can do? As far as mental limitations, they're looking at how well do you concentrate? How well do you deal with stress? Can you stay on task? If you were in a work situation and you needed to focus on a project or a task, if you would have limitations and difficulties doing that, that's the kind of thing they're looking for. Would you have difficulties actually showing up to work? Would you be excessively absent from work? Physically, they're looking at your ability to sit for prolonged periods of time. They're looking at your ability to stand, to walk. How many pounds can you lift? They're looking to see, well, what are your physical limitations? What are your mental limitations? I also want to mention that with Social Security, when they're looking at what kinds of jobs can you do, they're looking at your age. If you are a person who is under 50 years old, so I'm in that group, then I'm considered to be a younger person under Social Security's rules. So they assume that I should be able to, even if I can't be a lawyer anymore, I should be able to learn something else and do a different type of job. So they're really not concerned with, are you doing a job that's on the same level as what you used to do or how much money you used to make or anything like that. They're really looking at physical and mental limitations and whether or not there's any other type of job you can do. Once you hit 50, then the rules start to relax a little bit for proving Social Security. And then once you hit 55, that kind of puts you in a different age group. And they assume that the older you are, the harder it will be for you to learn new skills and transfer and do a different type of job. I also wanted to mention that Social Security isn't really concerned with the fact that if the economy is bad, because you all are probably thinking, well, who would realistically hire a person who had XYZ limitations? They're not really looking at that, to be honest with you. They're just looking at physically and or mentally, are you able to do any kind of work? So if you're able to make it through those steps, then you can be approved for disability. As far as the actual claims process, you have the initial level, you have the reconsideration level, then you have the hearing level with an administrative law judge. If you need to be in a position to appeal and go beyond that, there is the appeals council level, and then even beyond that, you have the federal court. So I pulled some statistics, and the latest statistics I was able to find basically showed that at the initial level, about 2/3 of cases are denied. So I'm sure you all have probably heard, well, most people get denied, initially. And based on the numbers, that's true. After the initial level, if you file the appeal and go to reconsideration, the numbers get even worse as far as the approval ratings are concerned. Initial and reconsideration, it depends on where you live as far as how long it takes, but generally in this area, it's about 4 to 6 months to get a decision. And then if you're denied, you have 60 days generally to file an appeal, and they allow a few days for mailing, but generally it's 60 days. So if you're denied at initial, you want to appeal. If you're denied at reconsideration, you want to appeal. And that's a mistake that a lot of people make. They don't appeal for various reasons. And, it's one of those things that you want to keep going, because if you don't appeal, then you have to start all over if you are still disabled and you decide to file later. Once you get to the hearing level with an administrative law judge, then there's a wait. Generally, it's about a year to a year and a half to even have your hearing with the judge. Once you get to the hearing, basically, it's going to depend on what judge you get. And if you have a representative, they can kind of talk to you about the judge if they know the judge and the judge's personality. It's just like anything. Judges are people. They have personalities, and literally sometimes you can have, I've seen the same case or the same fact pattern, and you get 2 different outcomes depending on who your judge is. But basically, the judge is going to ask you a lot of questions about your limitations and why it is you don't feel that you can work. Your representative, if you have one, will also have an opportunity to ask questions at the hearing. Usually, they will have vocational experts at the hearing, and the expert will testify, as I mentioned earlier, about your past work and what it takes to do that job. Sometimes the judges will also have medical experts testify at the hearing, and the judge will give the medical expert different hypotheticals and fact scenarios, and then ask the expert to comment. So I'm getting the indication that I only have 5 minutes left, so I'll speed this up. But basically, I want to talk about how can you help your case and some of the things that I see. So, if you leave here with nothing else today, then just know that if you're going through the process, your medical evidence is everything. And basically what I mean by that is all of the limitations that you have from your condition, you want to make sure to the best of your ability that that is actually documented in your records. A lot of times people will have treatment and they go to the doctor and they tell the doctor, I have this issue, I have that issue, or the nurse or whoever they're treating with, but sometimes that just doesn't end up in the records. And to Social Security, if it's not in your record, it doesn't exist. So if it helps you, I always suggest keep a list, keep a diary of your symptoms, what you're going through. If you're in the bed for half of the day because you're fatigued, if you have problems concentrating, if you have memory issues, depression, if you are weak, whatever it is, keep a diary of what you're going through. So that way when you go to the doctor, you can share that and ask your treating person, ask them, please write down my symptoms, because the first thing the judge is going to do is look in your records, and if they don't see it, it doesn't exist. The doctor spoke earlier about neuropsychological testing. That can be very helpful when you're going through the disability process, because the testing can show, where are your weak areas, where are your deficits, and hopefully give a better picture to the adjudicator as far as the difficulties you would have with being able to sustain any sort of work. So your medical evidence is everything. And in conjunction with that, what I would say is try to have open communication with your doctors about what you're experiencing. I see a lot of clients who, when you go to the doctor, you don't want to be the complainer. You don't want to be the person when the doctor says, well, how are you feeling? You don't want to be the person to say, well, I'm really not feeling well. When you go to your doctor, you don't want to be that person. If you are actually experiencing limitations, when the doctor asks, how are you doing, the answer is not fine. Because generally they will literally write, patient says they're doing fine. And then what the judge says in the hearing is, well, on this day you told the doctor you were doing great. So you want to make sure that you're honest with your providers as far as what your limitations are. And if you're thinking about filing for disability, then you want to make sure, if you can, talk to your provider and find out, doctor, do you think that I'm disabled? Do you think that I'm able to adjust to any other type of work? And if the doctor is supportive and doesn't think that you're able to work, then you want to find out if the doctor is going to go to bat for you, so to speak, and be there to support you with documentation and documenting your records in order to help your case, because that's what the judges are looking for. They're looking to see, what are your own doctors saying about your limitations. Now, Social Security will try to send you to treat, or not treat, but be evaluated by one of their doctors at a consultative examination. And, generally, if Social Security needs information that they can get from your doctor in the form of your doctor filling out paperwork, etc., that's usually the better way to go. I don't want to be overly negative about the CE doctors, but just know that in my experience, generally, they'll usually say that you should be able to work and do something. So it's usually better if you can have your doctor being supportive. I also want to talk about some pitfalls that I see. When you're at the hearing with the judge and you're testifying about your limitations, you want to make sure that you're honest about what you're experiencing, but there's also a credibility issue. And the judge is looking to see, are you overstating your symptoms? Are you exaggerating? So you want to make sure that, you tell the judge exactly how it is, be honest with how you're feeling and what you're experiencing, but you have to be careful with your credibility. You want to make sure that you have a dialogue with your representative, and that you tell the representative everything that you're experiencing, because we're actually here to help you. We're here to advocate for you. And if we don't know what you're experiencing, or I've seen there be some bad things looming out there, for example, drug and alcohol abuse. And that may come back to have an effect on your case. So if that is going on, that's something that you want to make sure that you're open with your representative about and that we know about so we can discuss it. I also wanted to discuss the fact that Social Security is a long process. It can be very discouraging, very disheartening, but you have to stick with it. And, you know, a lot of times it will depend on the judge you end up with, but you have to stick with it. You have to appeal. Make sure that you're getting the treatment. A lot of times, you know, you may have a financial issue where you can't afford treatment. You can't afford the doctors. In that case, you want to go to the emergency room if you can. You want to try to see if you can find clinical studies, free clinics, any place you can go to try to get some documentation to help your case. And I think I'm out of time, so I guess at this point I'll open it up to questions. Thank you.
During your discussion, you mentioned what you need to be to qualify for the disability.
Yes.
What are the requisites for qualification for the SSI versus the SSD?
Well, with SSI, basically that program is based on the disability test is the same. So with SSI, you still have to prove that you are disabled and not able to do any other type of work. The main difference is the financial requirement. And for SSI, that is meant for individuals who don't have enough credits in order to be covered under the SSD. So for example, if you didn't work long enough or more recently enough in order to be covered, they look at what your income is, they look at your assets, your resources, and if you are under those limits, then you might qualify for SSI. And then the monthly amount that you would get from SSI, to be honest with you, I can't think of the number now. I think it's about 600 and maybe a little more than that now, but that's the maximum amount that you would potentially qualify for under SSI, and that can be reduced depending on what your income and assets are, versus SSD is based on the years that you worked and paid in. And so from SSD, you may get $1,200 a month or $1,300 a month. Does that answer your question? Okay.
Oh, now me?
Yeah.
Oh,
Yes.
I'm talking for my friend Evelyn. She got diagnosed when she was 18 years old, and she got diagnosed and she started receiving SSDI, but she also got a student loan, and since that time, they were taking money out of the student loan, and she's already 34 years old, and she never went to school because she got diagnosed at that year, and she's fighting that right now. Is she going to be able to get that money back, or some of it at least?
To be honest with you, I'm not sure I really fully understand the question. Will she be able to get the money back from Social Security that they're taking out?
Because she never was able to do what she needed to do, so taking the student loan out was not good for her because she got disabled. But yet they're still taking money out of her SSDI till now.
What I would suggest, normally if they're taking money out of your check, there's an appeals process. There's usually an appeals process to fight them taking the money out. So I don't know if you have explored that, but if you were not able to attend school because of your disability, you may want to check to see, can you still go through the appeals process and basically say, I wasn't able to attend school. It wasn't my fault. I didn't intentionally, do this, and see if maybe they'll issue a waiver. I don't know if that's possible in this context, but I would look into that. I can tell you that if you have student loans that are in default, then, it's the federal government, so they can take money in some cases, but I would look into the appeals process.
Is it true that when you get an attorney, they take like a third of the money if you win your case?
If you get an attorney, with SSD, you can have an attorney. You can also have what they call non-attorney representatives who do Social Security as well. Both are bound by the same rules, meaning both can only charge 25% of your past due benefits, with the max being $6,000. It used to be lower than that, but say maybe 3 years ago or so, it went up to $6,000 as far as the maximum, whether you have an attorney or a non-attorney rep. So it's not a third, it's 25%. And then depending on whoever you're dealing with, sometimes there are other charges that are associated with administrative fees for your case that are separate from the actual attorney fee or representative fee that comes out of your past due benefits. But you're correct, there is a charge. It's not a third, it's 25%. Or the max being $6,000. And it's on a contingency basis, so that's only if you actually win your case. So you have to win in order for your representative to be able to get any payment. Yes.
Do you address any of the ticket to work programs at all?
We don't really deal with that, to be honest with you. The question was about ticket to work, and that's basically once you're actually on the Social Security disability, if you want to go back to work, they have certain what they call incentives to return to work. The only comment I would make about it is to say, once you get on disability, for most people, it's not a permanent thing. So they can always review your case, and they can always review to see if you have what they call medically improved. So you have to be careful with ticket to work and returning to work and different things, because if Social Security feels that you're able to now work and you've improved, then you're at risk that they could potentially terminate your benefits.
If you stay under the limits that they've set, that 1070 that you talked about, would they
It's
use
very
that to re-establish?
It's very case specific, to be honest with you, but I'm not saying don't work. If a person feels that they are able to return to work, then certainly I would not discourage that. You just have to know that you can be reviewed, and they look at your age and that sort of thing also as far as the review process, but it's something that you want to be aware of.
One last question then.
Sure.
I was approved before I was 50. I'm now after 50, but not 55. So it's still pretty tenuous, isn't it?
You're in that gray area, so
Okay.
yeah.
Thank you.
I'm not sure if this is your area of expertise, but I have a question regarding when a person is eligible and does start to receive Social Security disability, the gap in time or length of time before a person is eligible for Medicare coverage and
Yes.
furthermore Medicare Part D coverage. Can you speak to that if you have any knowledge of that?
Generally, I can say that when you are approved for Social Security, there's a date that's called your onset date of disability. From that date, for most people, there is a 5-month waiting period before you are entitled to your benefits. So, for example, if you are approved January, and it depends on the actual date, but let's say you were approved as of January 1st, then you would count that 5 months, and then as of June, you would be entitled to your benefits. So that would be your entitlement date. And then from your entitlement date, there is a 2-year waiting period before you are entitled to Medicare benefits. If you are approved for SSI benefits, then you would be entitled to Medicaid. So there's a difference there. But as far as the particular parts of Medicare that you're entitled to be honest with you, I don't know that. Yes.
Yes, is there Is this still going? Is there any negative aspect or penalty to starting the process by yourself? And by that I mean is assuming you get denied on the first round and then you go get an attorney for the appeal, can your application be restated, or if you made a mistake on it, said something you shouldn't have, are you stuck with that through the appeal?
Well, I'm an attorney, so I see gray everywhere. What I would say to that is, yes, you can file on your own. You don't need a lawyer or a representative to file. You can do it at your house online and fill out all of the paperwork and see what happens. If you get denied, and most people do, then at that point, I would say you may want to start considering getting a representative. The paperwork that you fill out for your case, starting from day one, is a part of the record. So judges definitely will notice if you, at the initial stages, let's say you fill out paperwork and you present one way and then you get a representative and all of a sudden the picture is bleak and you're presenting a totally different way, then, they're aware of that. Certainly your condition can change. So you can have, periods where you worsen and different things. So, I guess to answer your question, you can do it on your own. I would just, when you file, make sure that you think about all of your limitations and put careful thought into what are you experiencing on a day-to-day basis. Put careful thought into the type of work that you did before in the past. They have you fill out forms that ask about your work history. I mentioned that earlier. And, you want to think about, well, what exactly did I do in my job? I may have had a job title, but is that what I was actually doing? Because if you put down, for example, let's say you say, I was the CEO of whatever. Well, to the judge, they're thinking, okay, well, this person was the CEO, but you may have been actually self-employed working at home. So, you just kind of have to keep those things in mind.
I have a question. It's on the 55-year, that gray period you're talking, and
Yes.
also as a law firm, I have a federal disability retirement, which is different from Social Security. And is it harder because most law firms don't represent with the federal? Only thing I saw was like in Texas and DC to get a representative on the internet, and I did it myself. I got approved, but is it a harder way to do it?
I think to answer your question, if you're getting, and I'm glad you brought that up, if you're getting a federal disability, or let's say if you've gotten workers' comp or unemployment benefits, those are all things that can affect your SSD case. So with the federal disability, because of the offsets, it is hard to find representatives in that context. So you're right about that.
Gray area. What was that gray area she was talking about? The 55. She said she's under, and the lady who was sitting over there earlier.
She was asking more about the ticket to work, and my understanding is that she's on the disability, so she's trying to see should she or can she work and that kind of thing. So, by gray area, basically what I mean is that anytime you work, once you've gotten on disability, Social Security, they're going to review your case anyways, but if you're working, then they're looking to see, well, has this person, medically improved, and your age is a part of that consideration.
Any other questions?
First of all, thank you for answering a lot of these questions. I wish I knew
You're welcome.
beforehand. How do they determine how much you make every month, how much you get from?
It's based on your work history and your earnings record. I'm glad you asked that question.
I mean, is there a percentage that you get, or?
The formula, they have a formula, and to be honest with you, I don't know how they even calculate it, but they have a formula, and they look at, it used to be you would get an earnings record in the mail every year, but they've stopped mailing them, I understand. But you can access it online for free now, apparently. But you look at your earnings record, and it will show you. It used to be the green and white paper. I don't know if you all know what I'm talking about, but it breaks it down by years, and it'll show you what your earnings have been. And basically, they do the formula based on certain years that you've worked and that kind of thing. And then it tells you, if you were to be disabled, you would get this amount. If you have a family, you would get this amount if you were to retire.
Where do you look that up at?
On ssa.gov. And then there's a link, I believe, that's right on the home page where you can set up a Social Security account. And then, it gives you different options for downloading your earnings record and looking at some other things on ssa.gov.
And one last thing, thank you for telling everybody to do the certified letter. They lost things so many times over there, so make sure you make numerous copies of everything.
They love to lose
Yeah,
paperwork.
so that you have proof of everything. Make copies of when you're sending it out and everything else.
Over here.
Hi, you started off by talking about the work requirements. You said you had to have recent work to qualify for medical benefits, but isn't that a catch-22 when you're talking about being out of work for up to a couple years before you even can get approved?
Well, you have, basically, the way that it works, and it's kind of technical, but you have to, if you're 31 or over, 5 out of the last 10 years. So, one response I would say to that is that's why you don't want to delay in filing for your benefits, because at some point you are going to face your date last insured. So let's say that you have been working, paying Social Security taxes, and you figured out, okay, I can't do this, I'm disabled. You want to go ahead and file. Generally, at the point that you stop working, most people will be covered for about 5 years. You'll be insured for about 5 years after you stop working, but that depends on what your earnings have been. So, for example, let's say that you had some years in that 5-year period where you didn't make enough to get the full 4 quarters for that year, and let's say you only got 1 quarter for that year because you made $1,000 that year or whatever. Well, then that's going to shorten your insured period of time, if that makes sense. So file right away.
Is it true that you have to be out of work 12 months before you can even apply?
No.
Okay, because
No.
I'm getting told, I've gone on a couple different websites and
No.
filled out, and they say you're working
No.
too bad.
No. You want to, and I mentioned it earlier, you want to go ahead and apply if you feel that you are going to be disabled for 12 months, and hopefully if your doctor or your treating person has told you,
Well,
at least for the next 12
Yeah,
months.
she's already filled out the paperwork, but I keep getting this.
You can go ahead and file now.
Okay.
You don't want to wait the 12 months. Go ahead and file now, and then if if something changes and you're better, you can always withdraw.
I want to clarify something you said earlier. You said that for the Medicare, it's 2 years from the entitlement date. Is the entitlement date the first month that you actually receive your check?
No. You have your onset date, then you have the 5 full month waiting period. So the benefits technically start the first of the 6th month after your date of disability. And then there's the 2-year wait from that point.
So the 2-year wait starts after the 5 or the 6th month? That's when it starts?
Yes.
And it's a whole 24? So it doesn't go back to the onset date?
Right.
Okay.
It doesn't go back to the onset date.
All right.
Now, there are, with everything, there are a few minor exceptions, but that's the general rule. If you have certain conditions, then you may not have that 24-month wait.
All right, no more questions? Great, thank you.
Thank you.
So, again, we want to thank all of our presenters today. We started with Patricia Pagnotta, thank you. And Connie Easterling, thank you. I'll get to you. And then we had Chris Walker, right? And then Justin Konitzer, or was that the other way around? I don't even remember. Okay. And then Leslie Gaines, thank you. And again, we want to thank Teva Neuroscience, Genzyme, a Sanofi company, Genentech. We had somebody else. We had Accorda, Biogen. We had Genentech. I had to remember Genentech. And again, remember everybody, I have to give them thanks. I hope that you all recommend and know that we need the funding from these pharmaceutical companies to do the types of programs that we do. The dollar doesn't just fall off the trees. There are a lot of people out there that say, well, we're into the pharmas. Of course we're into the pharmas. We like what they do for us, and they are doing a tremendous amount of research. There are so many new medications that we hope to be able to see in the next 5 years that will greatly benefit not just you, but those still to be diagnosed. Again, thank you for coming, everybody. We're going to do raffles in a minute, but thank you, everybody, for coming.